The right to be forgotten online, especially in the case of Google and search engines, has divided opinion. Should people be able to edit their past? With me now is Rebecca Toman, Senior Associate from Carter Ruck, who is working on the case. Rebecca, the removal of information online and from databases, what's the fors and againsts?
So there's a very well-known High Court judge that said that what's online is like a tattoo. And because of that, you need to remove inaccurate, out of date or just false information, and you need to do it quickly before it proliferates. We as a firm act for many clients to help them take down information of that nature from Google and other search engines. It's important that you do this because if you don't, the record that exists now is online. It's not hard copy. So whereas you used to have newspapers which were published on one day and the following day they would be in the local chip shop as wrap, you don't have that anymore. You have these archives continually. So there is a real need to make sure those archives are accurate.
Well, the problem then arises that almost very rich people will be able to edit their past, such as we've seen recently with Naomi Campbell, and therefore other people who can't afford sort of your services will be left for their whole past to see online, no?
No, actually, because even before the very famous, or now famous, Google Spain case, we had the Data Protection Act, and there are mechanisms that you and I can use without the need of a lawyer, and you can fill out online forms, as we know, with the right to be forgotten, and you can apply to a newspaper or a publication under the DPA. You can do it yourself. You don't need the expensive legal advice. But what I would advise is that it does get very complex, and that's when you probably would be better off and have a higher success rate with someone who's done it before or has a legal background in that area, especially with data protection law, which isn't always as black and white as, for example, the right to be forgotten can be.
And just to clarify, is this to remove false information or just bits of your past that you're actually not proud of?
This is a very important distinction. So there are limitations as to what can be removed. And we've all seen the stories that hit the media as soon as Google Spain came out and Google started taking things down. And it was seen as some people were trying to erase their history. It's not a case of doing that. It's a case of inaccurate, out of date, or just false information that shouldn't have gone on record at the time in any event. And if that's allowed to be published long term, the damage actually that is done as a result of that it is quite high. We have clients that come to us who have 10 years ago been involved in a matter where they were the victim, and yet they are still feeling the effects from a business perspective because people Google you as soon as they meet you, and what's online really does matter.
Isn't it almost like opening a can of worms and sort of you're demonizing the big companies such as Google, because of course they can't really monitor everything that's online, and it's just so open, the internet, that how can you even stop sort of false information?
Google are doing their best. They've hired hundreds of paralegals to shift through the thousands of applications. But Google do have a control to a certain extent of that data. And what they do with this Google Spain right to be forgotten process is they take down the link. They don't remove the material. The material remains. It's the link that gets removed.
But Google is such a large company, isn't this just an easy target?
Google, because of Google Spain, have a role to play within the whole online world, in that we need them to cooperate with legislation. We need them to, if there's a rule or a case law that sets precedent, we need them to engage with that. And if they don't engage when you have cases that are clearly involving inaccurate, out of date or false material, that even under the DPA legislation that exists isn't being removed, there's a genuine case then to push and say, well, hang on a second, we hear what you're saying, but we don't agree and this should come down. And it's only when they're rejecting these claims for legitimate or illegitimate reasons, we would say, that we then press on with litigation.
Well, finally, I suppose the concern for a lot of people when it does come to sort of editing your past, that kind of thing, is a question of censorship. And is that perhaps the way we're going online?
Publishers really won't remove material if they feel that there is an element of censorship. Google have been known in the past with other, not right to be forgotten, but with other mechanisms of removing material to publish the fact that this material is being removed on the Chilling Effects website. So they've tried to create a balance, if you like, between what they're required to do and the people that are suggesting there is some form of gag. So there is an issue when you come to be taking down Google information. You have to advise your clients that there's also a negative side to removing material from online. There's the possibility that by taking those procedures and initiating the takedown process, that in itself will be made public. And then what you're trying to remove, everyone knows about. I mean, it actually happened ironically with the Google Spain case. It's a balancing act for the client to assess whether the information online is so damaging that they can't possibly afford not to have it removed.